background as to how we back into estate planning and how come it's important to think about and to do. So I'm going to show you some statistics that we all get At first one is not shuffle because we all are going to die. You just don't know exactly when and what is going to be left of our property when that happens. We also know that 85% of the time, men in the family are going to die first. Those are actuaries. We know from census information that almost 50% of U.S. households got children under the age of 18. And then we all know that as much as we love the matrimony, it doesn't, many times, 50% of the time, it does not last. So given those statistics, that sets up the need for estate planning because we're going to need your time and we need to have an orderly way to transition our property to those who we want to benefit. But it probably will not surprise most of you here to know that's not the top priority for those people. In fact, in our country, more than 2/3 of adults don't do the estate. That's the hard reality of it. And in the minority communities, African American and Asian and Hispanic communities, that's almost 80%. So if you've not started this yet, you're in good company, but you have time. And that ended up meaning that his 6 half siblings inherited the $200 million estate. Well, that's what Prince intended, but Minnesota, where he resided, said that's who got him. And so after several years of litigation, that's what happened here. If you don't have siblings, he didn't have siblings, rather, the nieces and nephews inherit equally. That guy who took give access to the viewers decided to get these siblings. So I think that what was intended there was that if you had siblings, would they predeceased you? So he had siblings who predeceased them, he took their children. That's the way I rescued. So I think that's what that meant. So, and on down the line. So you can see these are what we call rings of kinship. So we started way at the top when you had the wife and children, that's first degree. And then if you're out of that ring, we have to look to the next ring. So if there's nobody in that ring, you move to the next run and next run, so forth. And it's pretty intricate. So this is who's going to inherit from you if you've not done anything. And you can see it's fairly haphazard. You don't have control, then you're not sure that, like a Prince situation, not sure if that's what you really want to do. And testicity. It sounds like a little bit of a bad word, like the consonants or something, but it's testicity simply someone who has died without will. So when you have a will, you're called a tested descendant. If you didn't have a will, you're called an intested descendant. And as you can see, I talked through some consequences of being intested. You didn't do a will, some things can happen. Okay. One thing that can happen is if you have minor children, you could be leaving those minor children at risk if you don't do a will. And that's because the will is the only place where you could nominate a guardian to care for your minor children. So when you have a baby and you leave that baby without having done a will, and who knows, that's a very much of a risky thing. Somebody in the family maybe will take it, maybe grandparents will step up, maybe not. But, what could happen is if the poor baby's orphaned or foster care, or that one relative in your family that was the nearest well shows up to be the guardian for the child. In a similar vein, and again, looking at young minors, and one of the reasons I mentioned about 50% of our households have minor children, is because the lack of planning that impacts them probably the greatest. They're not able to defend. So if you die and you have left your assets to the child because you didn't do a will, or you didn't plan it, to say that they're at risk is understatement. This is probably a 6-year-old girl. Can you imagine if, her father and mother left and there's everything that parent or parents had together? Now, many people say they don't do estate planning because they feel like they don't have enough stuff. But I can tell you, for a 6-year-old, very minor, very modest amounts of money or property is too much, right? A 6-year-old cannot manage, or is not allowed to manage property. So what happens is that property has got to be managed by someone else, called an servitor. Once again, since you didn't do the planning, we don't know who that could be. That could be the greedy uncle. That could be anybody who decides, I get a commission for managing this kind of property. So I'll be able to inherit something or get something myself. So, and you're leaving your young child at risk without doing planning. Again, another concept principal test to see, and this is fairly, I won't say it's common, but it's not uncommon, is that family loan gets lost. Why is that? You didn't do any planning, so that if you all know that managing a property, that's pretty high level stuff. You've got to do a lot. You've got to write at least 2 checks a month to cover your property, whether you've got mortgage or not on it. There's something always going on with your property. All right. And so if you ended up passing away, and now who's going to do that? You haven't appointed anybody to do anything. No one's going to really rush to write those 2 checks that you're not going to be writing anymore. And no one's even allowed to because they can't get into your accounts since you haven't appointed somebody to step in behind you. And so in Georgia, many of you may know this, Georgia is a non-judicial foreclosure state. So if your house is mortgaged and you fall behind 3 months or more, the lender can put your house up for foreclosure, not have to go through any court or be a court order or anything like that. And so we do see this in probate. We'll see that before the executor or before the administrator can be appointed, that house could be up for foreclosure. And those courts don't work together. Probate court does not have jurisdiction to deal with the foreclosure. That's a different level of court. And so loss of the family loan is a real thing that happens if you don't do an estate plan. Finally, one more thing that's similar to losing a home, maybe a business. If you're a business owner, either in business with some others, or maybe you have your own business. Again, you don't know who that heir is going to be. So at the time of your death, what if your real first cousin? It's always those, right? They're looking for the opportunity to get into somebody. Your partners wouldn't like that. And it's likely that you're going to strain at business interest or put a strain on the business or maybe lose the business altogether because of that. So those are some of the consequences that occur when you don't do the planning. And so when you talk about estate plan, everybody gets a little bit scared when you say the word estate, because they start thinking about like a Ponderosa and the big, that was that one on Dynasty when they had the big move. So an estate is just what's left when you die. That term estate, that's what it means. It doesn't mean grandiose. It just means that's what's left, the property that you leave when you die. If you're not going to do something with that, those are the things we just talked about, maybe be problematic. But to do an estate plan, you really just need to make sure that you're making a plan for disposition of your property at your death. Also, while we're doing an estate plan, talk about other things too. During life, we need to do things. So we're going to talk, somebody's going to talk to you about what we call advanced directives, healthcare powers of attorney and durable powers of attorney. The idea is to leave your property in a way in an estate that does not cause harm or hostility between your family members. Okay. And so we talked about those reasons to plan, and I think the biggest one is the number 3. We talked about needing to protect minor children. That's certainly a good thing to do, preserving the family property. But I think one of the biggest things that escapes people when they fail to do the planning is the idea that you're forfeiting an opportunity. You're forfeiting an opportunity to say how you want your assets to go, to say to whom you want your assets to go when you die. Don't let the state that you live in give you your plan. And that's what will happen if you don't do the planning. Okay. And so how do we do the plan? So many times, as I said, people get intimidated thinking this is a huge project and I'm not going to be able to do it, or it's way too complicated, or the worst part is I got to talk to a lawyer. That's really scary. The thing that to keep in mind is an estate plan is kind of a basic thing. We need to get you a basic layer. And this is what you see is 3 documents, right? That I'm showing you. Will, financial power of attorney, healthcare power. That is sufficient. Can you have more than that? Absolutely. Depending on what you're trying to do and what you want to accomplish, you can have more. Can't you have less? I say no. If you come to me and you want to do a one-off, it's probably not going to work out too well. I hear a lot of people who say, I just want to get my will done. And I say, well, okay, come in and we'll talk. And then I'm going to have you do those other 2 things. And that's because the will is forward-looking. That's when you pass away. You're done. So you don't have to worry about you. But when you're still living, what about that? What about when you need some assistance when you're still living? And I think what we saw during COVID really opened a lot of people's eyes to the importance of those two advanced directives. Those are the places where you can name an agent to act for you. If you need assistance with managing your property, that's the financial power of attorney. If you need assistance with healthcare decision-making, that's your advanced directive of healthcare. And of course, during COVID, people were in the hospitals, nobody could get to them. And we got more phone calls of the daughter saying, I need to come in and do a financial POA for my dad, who was on a ventilator in the hospital. We can't do that. There's no way to make that happen because the person who owns the property has to be the person to do it. And so I just want to stress to everybody here the importance of the planning. And it takes, oftentimes people come in because there's been a tragedy, there's been a loss, and they got caught up in it and they realize that they don't want to do that to their family. And so I'd always say, better than I can talk to you or show you, I could show you this image. And that's the image we want to leave, is that connected family, that connected grandparents, parents, and the children there. This is what you're trying to accomplish, the family that's well settled and happy, connected. It's going to be benefiting from your property. And the way to do it is to do the estate plan. Right. Thank you.
I'm the estate planning attorney, also probate attorney. I also served as a guardian at Leiden, the Gwinnett County Probate Court. Personally, I immigrated from South Korea 27 years ago when I was 30 years old. Until then, I never spoke English. Since then, I learned the language, I learned the law, and I passed the bar in 2017. I've been practicing law in Georgia the past 7 years, now 8 years. And before I forgot, I want to tell you that the pen on your table, that's my pen, not Emory pen. That bought it for you, and take it with you. That is my business card as well. That's my business card. I was given 10 minutes, but the 1 minute is gone already. So I'm going to focus on mine. Oh. She did a great job with the will plan. I'm going to focus on his trust plan. The key word in my presentation is the how. There are many reasons why you're doing estate planning, but one of the more important thing, very important thing is to get the power. If you don't have your estate planning in place, then you'll have to go to the court to get the power. Let's say your husband who is a businessman who passed away, and then you as a wife went to the bank, goes to the bank, tell the bank people, hey, my husband has a bank account here. And the bank people will tell you, I'm sorry. Your husband's bank account is frozen. I cannot do anything until you bring me a court payer. And then your husband left the business, and then the business needs to sign the renewal of the lease, and you cannot do anything. Thank you very much. So, without proper estate planning in place, you will have to rely on the court proceedings, such as probate, conservatorship, or guardianship, which is not easy, it's not cheap, it's not quick. So, among these documents, I'm going to focus on the will and trust. And then let me highlight the difference between the trust and will. The will cannot avoid the probate. The trust can. Why? Because when you create a trust, you actually transfer the ownership of an asset from your name into the name of the trust. But the will does not change the ownership of the asset. So the retitling is necessary to the trust, will does not. And then will does not take effect until you pass away, but the trust become active the moment you sign the document. And then when it comes to privacy, the trust is a private document, but the will is a public record. So the moment you file it with a court, it becomes a matter of public record. Anybody can access it, even your enemy. And additional cost, unless something really major event happens, you don't have to pay any additional cost for trust most of the time. With the will, you will have to hire for an attorney, maximum attorney like It's too late. So there are a little bit difference here. And then what is a trust? Trust is a kind of basically document or agreement. And then also it is kind of relationship between these three parties. So here is the creator of the trust, grantor, and trustee, the manager of the trust. And they're making promises to each other. The grantor said, I'm going to give you my asset. And then the trustee make a promise, say, okay, I'm going to take care of your business, your assets, for the benefit of your family. So they're making promises for the benefit of this guy, beneficiary. So there are three parties, and then trust is like a legal relationship among those three parties. And then when you create a living trust, which is the most typical common trust, you're going to serve as a trustee, you're a grantor, trustee, but also you are going to get the benefit as a beneficiary. You're doing all those three. But when you cannot serve as a trustee anymore, then the person you name as the successor trustee will serve, successor trustee. And then during your lifetime, you will get all the benefit from the trust as the beneficiary, lifetime beneficiary. But once you pass away, the person you named as a beneficiary will start getting all the benefit. And that is after that beneficiary. So you specify in your trust and who is going to be your trustee and how they're going to receive their share. So you specify all those things in the trust documents. So the whole trust is based on very special relationship between the trustee and the beneficiary. It is called fiduciary relationship, meaning the trustee has a very important high-level duty to act in the best interest of the beneficiary. So once you create your trust, funding is very important. Let's say this is your trust, it's like a bucket. And then funding is like transfer your asset from your name into the name of the trust. It's a retitling. So you put your house in there, and then your bank account, or your business, or your retirement accounts, or your commercial property or personal property. So these assets are in the trust now, it is funded. And then the trust documents will govern all the properties inside the trust. But if you have any property that is outside the trust, that cannot be, the trust cannot do anything about this property. But all the property inside the trust, it is non-probate asset, meaning these assets are not subject to probate court anymore. So all your assets are in the trust, then none of your family member would have to go to court to get the power because you already gave your power to your spouse, your children, or trusted family members. So this is funding. And when it comes to trust, there are two different types of trust. One is a revocable trust. The other one is irrevocable trust. So, this irrevocable trust tends to be used by a lot of, rich people. Like they had like $100 million. And then they would put $50 million in this trust. And they don't have to worry about control because I can just set aside $50 million for my children or my grandchildren. And that will serve greatly for the purpose of asset protection and tax reduction. But a lot of time, people want to preserve control of their property. During their lifetime, they want to sell their house. So they want to do whatever they want during their lifetime. If they want to sell or give or exchange, they want to do that. So a lot of people, like 99% of American people, do revocable living trust. And then even those people who do the irrevocable trust, they start with a revocable living trust because in your revocable living trust, you can set up another irrevocable trust inside your revocable trust. And then, so revocable trust is like this. It's a bucket without any sealed lid. It is wide open, and this asset can go out of the trust anytime. You can add more asset into the trust. There's no restriction. It is all free. But irrevocable trust is like this. It is completely closed. So your creditors or your judgment holder against your property or your divorce court cannot reach in the asset here because it's completely closed. And also, not only those people, but yourself cannot reach in those assets because it's completely closed. That means you cannot control your property anymore. This is inside irrevocable trust. So if you choose asset protection or tax reduction, you're going to lose control. If you choose control, you're going to lose asset protection and tax reduction. You have to make a choice. But I can tell you that 99% of people need revocable living trust because they want to control their property. So there are many reasons for trust, setting up a trust. The main thing, the kind of primary, the most kind of important thing is avoid probate. Because if you put your asset into the trust, then all the assets of the trust are outside the jurisdiction of the probate court. So when you pass away, or your wife pass away, your children will go to court. What do I do with this asset? The judge will tell you, well, don't come to me. I do not have any jurisdiction over this property. So do you do whatever the court or the trust document tell you to do? So avoiding probate is kind of number one, and also a tax reduction. Because by using this irrevocable trust, either as a separate trust document or the subtrust under revocable trust, you can utilize this irrevocable trust for estate tax reduction or GST tax reduction, or you can even utilize your revocable trust for income tax purposes. For example, if you purchase your house 20 years ago, and that purchase price was like $200,000, and 20 years later, now it's like $500,000. And if you give the house to your children now, before you die, it is a gift, not inheritance. In that case, your child will inherit those kind of tax bases, which is $200,000. So after your passing, if your child sell the house and the market price is like $500,000, then your child is subject to long-term capital tax liability for $300,000. But if you put your house into the trust and they give it to the children after you pass them, then their tax basis will step up all the way to the market price, $500,000. So if the child sells the property right away, there'll be no long-term capital gain tax. So tax benefit also, if you have any children with a some kind of issue, drug issue or gambling or something like that, and then you don't want to give that their share right away. You don't want to give them outright. You can put their share in a separate share trust. And then you can kind of set a manual saying that maybe you can withdraw money like $100,000 per year or $50,000 per year until you reach the age of like 40, 45, or 50. So you can kind of specify all the regulations and rules for the inheritance or distribution. And also, if you have like a blended family, so this is your second marriage, and I have my own children from my first marriage, and she has her own children from first marriage, then it is it's a very sensitive issue. It creates some kind of conflicts. And then depending on who died first, what's going to happen to my child? So people are concerned about those situations. So you can specify what should happen no matter who dies first. So you can put down all the kind of rules about distribution after your passing or your spouse's passing. And also, because like I said earlier, when you create your revocable trust, a lot of people set up a irrevocable trust inside the trust, such as like a credit shelter trust or family trust or special need trust or minor trust. Depending on your needs, you can create those kind of irrevocable trust. So anything inside an irrevocable trust provide asset protection, even though your revocable trust does not provide asset protection. Some people ask me, hey, I want to sign the kind of revocable trust. Does that give me asset protection? No, because that is wide open. There's no sealed leak. It's not closed. So it is not protect from your creditors or something like that. But any irrevocable trust, inside trust will give you asset protection. And also, if one of the beneficiaries, like your grandchild is the beneficiary, but that person is a special person who is receiving a government benefits, or is applying for government benefits such as SSI or Medicaid, then you don't want to lose that because it is pretty good stock. So you don't want your grandchild who is a special ed person to receive their share directly. So you have to create a special ed trust. So her share will go to her special ed trust instead of to her directly. So that way she can continue to receive the government benefits while preserving my share in the separate trust during our lifetime, and upon her passing. But any remaining trust and any remaining funds can be inherited to their children. So the family asset will be preserved by putting them in the SNT instead of giving them directly. So there are many different reasons why you have to create trust. And then, a lot of time, I have a lot of assets. So I want my children to get their share right away, immediately. A lot of people want that, but some people say, like the client that I had today, they have 3 children. The middle child has kind of issue. She never diagnosed as kind of serious disability yet, but the parents believe that my daughter cannot handle her financial matters. So I decided to kind of create another special separation trust, and then I'm going to name her brother as a trustee of this trust. So, and then also the parents and I agree to say, okay, this trustee, the brother trustee, will be compensated like, $50,000 per year or something like that, for taking care of his sister. So, depending on the situation, it's not going to be outright. The distribution will not be outright. It's going to be ongoing trust. So during the life of this sister, let's say 30 years or something like that, it's going to be ongoing trust. But during your lifetime, you can change and revoke your changeable language of this trust anytime you want. But once you pass away, your revocable trust will become irrevocable because you cannot change it anymore. So your children will have to do the last tax filing as an irrevocable trust. So they will have to obtain EIN, the tax ID number, and then they will have to file a separate tax return. So any question, you can ask me a question later, but this is all I have today.
One. Hopefully y'all are learning a lot. I see people taking notes, which is really, really good. So I took been tasked with talking about the Georgia Advanced Directive. So full disclosure, my part of the presentation is going to be a Debbie Downer. It's going to be a little sad because most of us don't want to think about passing away. Like we really don't talk about it in the society. We just kind of know it's going to happen. We saw it on the presentation. 100% of us is going to happen. And we always kind of focus on our stuff. We talk about our will, we talk about our trust, and that's what's not happening to the pots and pans, what's not happening to the house, what's not happening to the car. But estate planning is more than that. And so usually with my clients, I say, hey, yeah, that's important. We got to talk about this stuff. We got to talk about who's getting vital. We got to talk about who's giving China, all of that. But what happens if something happens to you? And that's really where the conversation needs to start. The stuff is great. We'll get to that. But what, and especially during COVID, we saw that. We saw people who never in their years hadn't thought about, their own demise, contracted COVID and now was in the hospital. And nobody had given any real thought to, well, who's the decision makers in these types of situations? And so that's where the Advanced Healthcare Directive comes in. Who gets to make healthcare decisions for you in the event that you cannot? I was thinking long and hard, like how could I do this presentation? And I actually got an article that came across my desk because March 21st was the 20th anniversary of the death of a very famous young lady that most y'all too young to know, but her name is Terri Schiavo. So I'm gonna tell my age. Most black women don't ever tell their age. But I was 10 when Terry Shivo, who was 26, was standing in her kitchen and she collapsed. And she was rushed to the hospital. They never really knew what caused her to collapse. But she was put on a feeding tube and she was put on a ventilator. She was married. Her husband, Michael, said, you know, my wife would never want this. It's time to let her go. And her parents was like, oh, absolutely not. And so for 15 years, Michael and Terry's parents were in court. 15 years. They went all the way up to the Supreme Court. President had something to say. Pope had something to say. All of America had something to say about what should happen to Terry Shivo. Only person who didn't have something to say was Terry Shivo. Because Terry never wrote down what her wishes were. She never said who was supposed to make that decision. Was that supposed to be her parents? They had known her longest. Was it supposed to be her husband? They known them her 7 years. Who makes that kind of decision? And so America was cut down the middle. It was like 51% sided with him, the rest out of the man. The rest sided with her parents. And everybody has something to say about it. And by the time a judge finally ruled and said it was time to take that feeding tube out, I was in my second year of law school. I was 10 when she collapsed. So could you imagine your family having to figure that out for you for 15 years? Now, because of Terry Shivo, the law has changed drastically in this area, including here in Georgia. So Biden, 05, 07, Georgia said, okay, we got to figure this out. And so we came up with the advanced directive that I get to talk about because it now replaced what we used to have back in the day, called a living will. So if any of you say, oh, cross that, it's only so old. And then we used to have what we called power of attorney for healthcare. And so between the living will and the power of attorney for healthcare, everybody was just, it was just too many places to do too many things. And so in July of 2007, Georgia consolidated that all into the document you got on the table, which is the Advanced Healthcare Directive. So this document allows you to get your say. Unlike Terry, you get to say who makes those types of healthcare decisions for you in the event that you could not. So if you have a terminal illness and there's no likelihood that you will recover from that illness, or you have been in a permanent state of unconscious, this document allows you to say, what would you want in either of those situations? So I'm not gonna go through the document now because I need y'all to stick around, but when I go into detail during our breakout session. But think about, I told the story of Terry because I want you to think about what you would want. What would you want? Would you want to have your say so? Would you want your family sitting in court for 15 years trying to figure this thing out when you have an opportunity through planning to be able to put down on paper what it is you want and have your say in what type of treatment you would want? Who would make those decisions for you? Even how do you want to go out? You're going to be buried, you're going to be cremated. You get to put all of that on paper. And so people aren't sitting in court for 15 years trying to figure it out. All right. So y'all join me for the breakout. We'll go in depth on the different parts of the document. And I'll talk to you about what the different preferences are and what you can select from the document. But that's my presentation.